Welcome to Your Success TV. I'm Ken Wells, your host, and today we're going to be talking about how to have a valid, legal, enforceable separation agreement. And today I'm joined by John Schuman from Devery Smith Frank. John, welcome to the show.
Good to be here again, thanks.
So today we want to talk a little bit about getting some practical advice on separation agreements. And I guess I'd like to start off just by asking, so how do couples finalize matters between themselves after separation?
Well, there's two ways you can finalize things between yourself. The first is you can have a judge or an arbitrator order it, which means the judge or the arbitrator imposes the term that you and your spouse will live by. Or the other way is to have you and your spouse come to an agreement over the terms that you're going to live by for the rest of your life. And there's no other way. It's either you have it imposed or you come to an agreement about it.
Okay. So are there any rules to have a valid separation agreement?
There's a number of rules. The basic rules are that you have to well, there's three basic ones. It has to be in writing, it has to be signed, and it has to be witnessed. Those are sort of the basic legal rules so that what you have on a piece of paper can be called a separation agreement. However, if you want to have that separation agreement have any weight, if you want a judge to look at it and enforce it later on, because ideally you want that agreement to be held, your spouse to be held up to it if things go bad later on. You want the judge to say, yeah, you're going to follow the agreement. And if you want the judge to force your spouse to follow the agreement, then there's a number of other rules you have to follow, because just those three rules about having it in writing, signed, and witnessed are not enough to have a judge enforce it.
Okay, so what are the other rules that you need in a separation agreement for it to be enforceable?
Okay, so the other rules, they come under a section called Section 56 sub 4 of the Family Law Act in Ontario, and they come under three headings. The first is that the parties have to understand the agreement. And understanding agreement means you have to understand the legal document that you've signed. And pretty basically that means you have to have a lawyer. I mean, very few judges are going to let someone get off with a separation agreement and say they understood it if they don't have a lawyer at the time who signs a piece of paper that says they understood it. And whenever lawyers do separation agreements, there's a piece of paper at the end that the lawyer signs to say that their client understood the separation agreement. So that's the first thing. So think of the first criteria as being you need to speak to a lawyer.
Okay.
The second is you have to exchange financial disclosure and meaningful financial disclosure. You have to disclose all of your significant assets, liabilities, and your income. And the idea behind that is sort of similar to the understanding part of the agreement. If you're giving up something in the agreement or you're taking something in the agreement, if you're trying to evaluate whether the deal is good for you or bad for you, the only way you'll know if the deal is good for you or bad for you is if you have financial disclosure from your spouse. To know they don't have other assets you didn't know about, to know they didn't have other debts you didn't know about, to know their income is what you expected. If you don't know those things, then you probably didn't know whether the agreement was good for you, which means you probably didn't understand it. So the second criteria is you have to exchange meaningful financial disclosure. And when lawyers do that, we do that in a way so not only is there a sworn financial statement, so there's something that has a bit of oomph behind it in terms of saying what you have and what you earn, but also we exchange a package of financial documents that goes to the other lawyer so that in the event your spouse in the future says, I don't like the separation agreement before, I didn't get enough information to understand the agreement, we have that package that you can then show the judge and say, no, they understood, here's exactly what they got. And so that's part of another reason why you had a lawyer, to make sure that disclosure process is formalized. And it's really important. That's the most common way separation agreements get set aside, is because the spouse said, there's something I didn't know, and if I had known it, I wouldn't have signed this agreement. And sometimes that can even be really small. So you really want to have your disclosure done upright. The third is a broad category. It says otherwise in accordance with the law of contract, and that covers a lot of things. It covers all, first of all, you have to obey the law of contract. In order to make sure you obey the law of contract, if you're not a lawyer, you need to know the law of contract, and the law of contract goes back hundreds of years, started off in England. So if you want to know all the rules of contract, you're either going to do a lot of research on your own, or you can speak to a lawyer to make sure nothing you do violates the law of contract. There are certain things in the Family Law Act that add to the law of contract that make your agreement unenforceable, like if you have a clause that requires chastity. Those aren't allowed, but in order to make sure you have all the rules, you need to speak to a lawyer to make sure that you don't violate any laws of contract. Another thing that you have to do that in accordance with the law of contract is you have to make sure the agreements were fair, because agreements can be set aside if the negotiations weren't fair. So if one party had extra power, or put the other party under duress, or there was some hiding or the table deals or some other sort of weird pressure going on, then the whole agreement can be set aside. And that would be in accordance with the law of contract. And the way you ensure that you don't end up in an unfair bargaining position is you hire a good lawyer who makes sure that you're protected in your negotiations. And the last one that comes under that category of the law of contract is that your agreement has to reflect not only the law, but that you've considered your futures going forward. And that came out of a Supreme Court case in Canada that says that the separation agreement is a sort of a future-looking document. It covers what your life's going to look like going forward, and you have to contemplate all the circumstances going forward. So if your spouse can say, what's happened to me now is not something we ever contemplated when we signed the agreement, then that'd be another reason why a judge could set aside the agreement. So you have to have terms in your agreement that say you've contemplated the full range of things that could happen to you later in your life, that you could get sick, you could get injured, you could lose your job, you could have a financial disaster, you could do financially very well, win the lottery. All those things have to be contemplated when you're signing the agreement, and you have to, having contemplated all those things, still agree that the agreement you've signed will be fair.
Okay. So what about those people that are trying to save money, right? Because lawyers are expensive, right? And they go to the store and they get one of those store-bought agreements, right? Would that work for them?
They almost never do, because separation agreements are really technical documents that have a lot of things that go in particular to people's circumstances. For example, the financial disclosure. The store-bought agreement is not going to tell you what financial disclosure to disclose in your circumstances. So you may be a general list, but if you have stock options, you disclose them. How do you disclose them? What do you disclose about them? What documents do you know? If you have a pension, what do you disclose with regard to the pension? What documents do you have to fill? What documents do you have to get from your employer with regard to the pension? What bank accounts you disclose? What about if you have investment? How you disclose investments? So those are all things that you need to know in order to make sure your agreement's enforceable. And you have to make sure you don't miss anything, because if you don't disclose everything, your agreement's not going to survive. The other thing the store-bought agreements don't do is they don't really give you an idea of whether what you're doing is fair or not. So if you come up with an agreement you think is, fair, but you don't really know because you don't know how to value a pension, you don't know how to value stock options, you don't know how to estimate your spouse's future earnings. So in all those circumstances, do you know whether the agreement's fair? Are there some peculiarities, like a matrimonial home that throws off the whole calculation, or an inheritance, which also throws off a calculation? Do you know all that? The store-bought agreements are not going to help you figure out whether the agreement's fair, and you're not going to know for certain. It may seem fair, but then you may go to a lawyer afterward and say, oh, I could have done so much better. So that's a good reason just to see a lawyer to make sure what you're talking about is fair to you, and you haven't, given yourself a bad deal. The other thing they don't really contemplate is this whole idea of the forward-looking idea, because that's a big part where lawyers do a lot of the special drafting to fit the circumstances, to say that you and your spouse know what you're doing and you're thinking forward. And if you need to tailor that towards the people who are doing the agreement. So there may be special circumstances in your family that aren't the same as everyone else's family. And if you just use a store-bought agreement, you're not going to get those in. So you need to have special drafting to meet your specific circumstances. And the only way you're going to do that is going to speak to a lawyer to get the special terms in that you need, that makes the agreement fair to you and that makes it last for you. Using the standard boilerplate clauses will not do that. And the standard boilerplate clauses usually aren't sufficient by anyone's imagination or any lawyer's imagination in any event. They're woefully deficient even before they're modified. So you need to use an agreement that's been drafted by a lawyer. It will last you much longer and save you a lot of money in the future if you and your spouse ever have a future disagreement.
Can a couple use one mediator opposed to using two lawyers?
No, and there's a few reasons why that's the case. Even if you have a mediator who is also trained as a lawyer, as in their role of mediator, mediators are not allowed to draft separation agreements. Separation agreements can only be drafted by people on their own, which I said is probably not a good idea, or by lawyers. And if you're acting as a mediator, you're not acting as a lawyer, you can't draft a separation agreement. In addition, mediators' jobs are different than lawyers, and that's an important thing to consider. The mediator can come up with an agreement that recognizes the specifics of your family, which as I said was important. That's a good reason to use a mediator, to come up with a deal that meets your family's needs. But one thing the mediator can't do is give legal advice and cannot tell you whether that deal is good for you or bad for you. And the mediator's job is not to come up with a fair deal, it's to come to a deal. People sign for a mediator to say they want to settle the matters between them. And they can settle the matters in a way that's really unfair to one party, and that party may not know about it. So in order to make sure the deal is fair to you, you need to have some knowledge of the law, and you should have a lawyer in the background. You can have a lawyer go with you to mediation, or you cannot have a lawyer go with you to mediation, but it's really helpful to meet with a lawyer before you go so you know where you should be, what sort of deals you should be signing and what sort of deals you should not be signing. In addition, once you finish the mediation, the idea is you're going to come to a settlement. But in order for your settlement to be enforceable, you have to put it into a separation agreement that's legal, enforceable, and binding that the judge will respect in the future. In order to do that, you have to meet all those criteria that I just spoke about. And as you've followed along, that means you're going to need to see a lawyer to sign off on everything after the mediation. Now, if you go see a mediator after the mediation and the lawyer explains to you the agreement and what could have happened otherwise, if you had followed the law, or if you'd gone to court and then you think, oh, I should have gone to court, it's much better for me to have gone to court than sign this deal, then you might back away from the deal. So it's better to have the lawyer involved earlier on to tell you what sort of deal you should be signing, and so that you come up with a deal at the end of mediation that the lawyer will say, you know, that sounds like it's probably a fair deal for everybody. You can sign it off, formalize it, make sure you have everything done you're supposed to do, and move on with your life with a signed separation agreement.
Okay, so is an agreement as binding as a court order?
Agreements can be filed with the court and enforced as a court order. So they are as binding as a court order. If you want to give a little extra bit of certainty, you can actually convert your agreement into a formal court order. Converting your agreement into a formal court order requires the judge to look at it, look at the financial disclosure, and agree that this looks like a fair deal. And if you do that, then the Supreme Court of Canada says that's a harder thing to change, much harder to change than just an ordinary separation agreement. So if you're worried about things getting set aside, you can go and have it converted into a court order. But otherwise, if you're worried about collecting your support, then having a separation agreement is fine, because you can just take that to the court, file it with the court, and they will enforce it as a court order.
Okay, so does it still make sense to do an agreement versus going to court? Like, is it best to get it out of the way before you get to court?
I think it's much better to do an agreement than go to court, because one thing you have to understand is court is more expensive than most people can imagine. Much, much more expensive than most people can imagine. And in most cases, it's not necessary. If you can find a way to come to agreement, then you should come to agreement, because not only is it less expensive, but it allows you to tailor the terms to something that you want. A judge imposes terms based on what the judge feels like that day. But if you want something that reflects your family, you need to do an agreement. So if it's difficult to come to agreement, by all means, use mediation, use collaborative, have an arbitrator help you, have your lawyers help you, come to an agreement. It's only in the cases where there's no possibility of resolving, and there's a serious power imbalance or violence or mental health issues, substance abuse, where you really do need to go to court. And if you can avoid going to court, then you'll save yourself a lot of hassle, a lot of money, a lot of stress, and a lot of emotional upheaval. So do the agreement right from the beginning, and have a lawyer help you, and then you'll have your affairs settled in a way that makes you much happier in the end.
Okay, great. So that brings us to the end of this episode. So John, thank you very much. I hope that I hope you're not even going through a separation agreement, but if you are and you do need some assistance, by all means, you should give John a call at Debbie Smith Frank. And I thank you for watching, and we'll see you next time.